Hi there. How are you doing? I trust all is well today, and I trust you can hear me.
We can, yes.
Excellent. Well, welcome back to the OpenChain webinar series. Incredibly, we had 35 webinars since we started in nearly mid-2020. And this year we'll continue with bi-weekly webinars. Our focus, as always, will be on trying to make sure you have information that's directly useful to what you're doing at work. So we're always trying to focus on what's happening around open source law, open source processes, and other adjacent areas that can help you do your work better. Today, we're starting off the year with something profoundly important for the use of open source. In Italy, the GPLv3 has had its first successful enforcement case, and we're very fortunate to have two of the council with both a long history in open source, two of the council from Array Law who are behind the case and can explain to us precisely what happened. So we have Carlo and Alberto on the line. Now, before we get started, as usual, I'll just highlight that the Linux Foundation has an antitrust policy that applies to all of our meetings. The full antitrust policy is on our website, and if you're from a Linux Foundation member company, you can ask our counsel, Andy Updegrove, any questions you may have around it. If at any time you have questions about the antitrust policy, you can also reach out to me. We mention this at the beginning of every meeting because we are a huge global community in OpenChain. We're an even bigger global community in Linux Foundation, and we want to make sure everyone knows with great clarity how we do things. Speaking of how we do things, back to fun. This webinar will be a presentation, but like all of our activities in the OpenChain project, this webinar will also be somewhere you can raise questions. So please don't hesitate as the webinar is underway to ask questions. I'm sure both Carlo and Alberto are perfectly fine with that. And additional to this, of course, if you have broader questions, you may also find other participants have something to say. OpenChain is a community of user companies working for user companies, and we are here to share our knowledge and experience. With that, we have a lot of people dialing in, which is great. We're also recording this webinar, and we will have the long tail audience. I'm going to hand over to Carlo to introduce the topic and speak through the recent success they've had in Italy regarding GPLv3. Carlo, the floor is yours.
Thank you, Shane. Much appreciate being here. Thank you for inviting me. This case is minor in importance in a general picture, but in my understanding, it can be interesting in some aspects. On the one hand, this is not on the usual, they didn't give me the full source code, because this is a case about a WordPress plugin. So it's a case where full disclosure of and provision of full information and full source code is not the main topic. And this is quite a weird case because I wouldn't expect it to hit the core, because the fix was very easy, but the other party refused to comply. So we ended up, and quite swiftly, we achieved and sort of unexpectedly, we achieved a good result, a win in a case. So without any further ado, the time is quite short. Let me just open my very brief presentation, and hoping that everything goes well. I'm sorry, Alberto couldn't participate for some sort of breakdown, but I'm pretty sure we are in alignment, and I'm, apart for some technical question, I'm sure we are fully aligned in whatever we say. So very briefly, we are speaking of a plugin for Elementor. Elementor is also a plugin to WordPress. So it's a software that adds functionality to web pages hosted by WordPress. The company is a small company in Venice called Ovation, and the plugin is called Dynamic or Dynamic Content for Elementor. Everything is GPLv3, there is no question about it. And also the alleged infringing plugin was and is currently under GPL. So no question on share alike. It's actually two developers have left or have been sent away, depending on whom you ask, and they form a competing plugin made entirely of PHP and JavaScript stuff. So and this was and still distributed without any minification or obfuscation whatsoever. So everything that is developed is put into the plugin, and the plugin is fully disclosed in source code. What has been violated is section 5 of the GPL, and precisely letters A and D, requiring full attribution when you fork the code. So the word must carry prominent notices stating that you modified it and give it a relevant date. And of course, if in this case, the plugin has a user interface, of course, in the administrative part, and there was an attribution, but the attribution was wrong. So the company distributing this plugin failed to, in our claim, failed to include a prominent notification and a prominent attribution. So we sent a termination notice. We decided that despite in theory, a termination notice wasn't required for many reasons, we decided to play it safe and to give a final chance to the developers to rectify, because they could have claimed that this was a first offense. So the quite complicated section 8 of GPL would have had a role, but in any case, they openly and clearly refused to comply. So there was even any scope in attending a grace period. So just by way of recollection, because maybe you are familiar with the generalities of section 8, but it is quite complicated to understand. I briefly and in another case we had in Italy, that was also for many reasons that has come to attention. So we scratched our head quite heavily, and we found that sometimes it's difficult to make an operative interpretation of it. So the basic rule is that if you violate the GPL, your license is terminated, but you have some grace, some redress. So in case you are innocent and the violation is without malice, you can, and it's first time also, you can remedy. So if you reinstate, the license is reinstated if you start complying and you don't receive a termination notice within 60 days. And if you are the first time that you violate, you have 30 days to restore violation. And quite important, once your rights have been terminated under section 8, you cannot use the license even though you comply. So once it's terminated, you have lost the rights forever, regardless whether you can receive the same word from other sources or from us. But for you are in a unique position in the word not to be able to use the code that for which your rights have been terminated. And this is precisely what we claim in court, and successfully so. So what the other party claimed against us. In the first place, they said, oh, no, this is not true. We are not violating because our product doesn't contain any of your source code. This was the first answer. So we have refactored everything, and there is nothing in our code that violates your rights. When in court and having provided the source code for both our product and something we have our people have recovered from buying the other plugin, they said, no, this is not true. You don't have copyright in the part that we are using because that was ours, not yours. And then they filed another defense, which is sort of contradictory. And yes, we copied something from your code, but your code that we copied in actually was our code that you copied out. So A copied B and B copied C, which is, in copyright is quite dangerous because then you say, okay, then you confess that you have copied from somebody else. So you expose yourself to the third party. But in this case, A and C was the same person, or C was a licensor to and the copyright holder to A. So in this case, it could have worked, but that was contradictory to the previous defenses, and that came quite late in the defense as well. So it's and this was considered by the judge as not really convincing. Another quite surprising defense said, well, yes, but it's normal that if the same author, the same developers develops the same function, it will end up doing the same thing over and over, which is not true. Because you can copy the generalities, so you can be you can evaluate the copying more in a different light, but you cannot replicate the same errors, the same quirks, the same comments exactly word by word, letter by letter. So it's the threshold we have met is much higher. But it is true that if you redo the code, my advice is always to avoid the same developers doing the same work, because actually it will end up doing sometimes the same thing, so raising questions as to whether the software has been copied. So we advise to do a white room development, so where the original developers describes the function, makes the functional requirements, and somebody else if you want to replicate the same code in the same space. So it's worth noting that this is something that it could have some merit sometimes, but not in this case, of course. What is the evidence we brought? Very simple. We say the proof of the case is needed, so we provided the entire source code. Our source code is public, as everybody can receive. Actually, somebody has even forked our software, despite our Git repository. My client's repository is not public. People can download software sometimes from other sources, having forked it, and of course you can buy it. And we did the same for the other part. The main evidence that we provided, besides the actual code, of course, for comparison, for analysis by any expert, is an analysis by an expert we hired, somebody you probably know very, 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 very public, but he doesn't want to be named here. And so we provided a forensic analysis where we show that, as I said, quirks, errors, and comments were common. So it's a quite strong indication that despite things having been shuffled around, the source code was indeed copied. So it was derivative. How much we didn't know precisely because it's quite a large source base, code base. And so in order to show the judge that this was not occasionally, was not de minimis, so it was way beyond any reasonable coincidence, we provided even a quantitative analysis. So we use ScanOSS, which you might be familiar sort of, because it's used for inventory purposes, but we use it in a forensic, strictly forensic way to provide evidence of how much of the code was common into the two source bases. Well, so we provided the two as a database of software to be compared against, and we found more than 8,000 occurrences of lines copied verbatim, snippets copied verbatim in places without any kind of changes. And actually, we found that ScanOSS is able to find literally copying, even if something has been changed, like the name of a variable, the name of a function inside the code. That will show up. Of course, it's not 100% precise. It has 4 positives, it has 4 false negatives, but it gives a ballpark figure that could be 50% less, 50% more, but something that is quite. And so it was originally we discussed with them, and they are quite interested in the way we use it, and they are also available to interact with people having similar demands, similar needs, and to help them technically. Actually, they suggested us to tweak a little bit the parameters and to have more accurate results in this particular case with less effort. So I have already I outlined what was our case in general. We provided proof of derivativeness irrespective of how much, 3,000, 400, 4,000, even if anything beyond a copyrightability threshold requires copyright permissions. So failing to mention and to make the proper attribution triggers section 5. And the quantitative analysis is useful first to show that it's a serious infringement, and second for damages. But damages requires a full merit case, so it cannot be claimed in an interim case because it was an interim case in urgency. That's important because people tend to think that there is once you have distributed the source code, you are home free. Actually, for many, especially for copyleft, there are more requirements, more obligations, and that's important. We are because we are advising a company for a large OpenChain compliance. We are trying to find a reliable database of the obligations in the various licenses used, so that complying with the requirement of OpenChain that you must know and make aware the organization which are for each license the relevant obligations that requires a database. So we are trying to build. Andrew Katz has been contacted, and we are discussing how to build, especially if you are aware of any of such database, even if incomplete. Please provide us in comments. Please provide us information if you have them. So sorry but it's quite important because it's important to increase the awareness of the complexity of the compliance in terms of what you have to do in order to comply. So Of course, this case is still pending. So when I speak of the other parties, it's my interpretation of what is their defense is not, I've no pretense to be 100% accurate. It's my view and my report. Please be reminded. So they, and judging from the court and the motives of the decision, and the other parties failed quite spectacularly to state their case in an ambiguous way. So they kept a moving target. They didn't pick up a defense and defended it. So provided and more of that, anytime they had to provide evidence of the code, they failed to provide the code. So they didn't have any forensic evidence. They just claim their defense was correct, but as I said, the proof of the case is in eating, and there was no cake. So the judge didn't order, as we expected, a full inspection by an expert, but relied on procedural grounds, so on the contradictory statements by the other party, which is something that can be done. So if you fail to be stating your case, you are losing, because you end up admitting something, and you fail to provide the counter argument that you are putting forward. So there was no evidence of what the claimed original code was, so we cannot state if there is anything not coming from this alleged source base, and that is admission of copy. So it's quite dangerous to put that in court. Another defense was it wasn't work for hire, but I will not discuss it because it's complicated. It's not that relevant here. So the end line was that the case was entirely upheld. So termination was effective. No right existed under the GPL, so GPL was not available to defendants. The judge issued an injunction to cease distribution until the distributed code was clear of any copied code. The judge was creative, and accepted some of the defenses that the code sometimes needs to be the same because it implements interfaces. So it says the judge estimated that 500 lines of code was permitted. Of course, we will not claim in case this limit is exceeded, and it's clearly required that this is copyright infringement. But actually, the case is different. But I will not comment on that. And the judge even offered damages for the line compliant, what we call astreinte or astreinte in French, and of course award of costs, which, despite being an interim case, because this case is by nature requires or permits to be permanent, and you are not anymore required to go in force case. Awards of damages is also granted. Another thing that we discuss is in order to have an interim provision, an interim measure, you must provide evidence of irreparable harm. And for this is something I've discussed many times. But in source code, you say, yeah, but what is the harm? You are not selling the software. On the one hand, the judge found that the copying of the source code is likely to offset some of the clients from one to another, so causing an irreparable damage, which is of difficult quantification. So it's better to stop it instead of waiting for damages in a full case, which will require at least 5 years. So, but we also claimed, and we reserve to claim again, that copyright violation is per se irreparable damage, because you have the right to enforce your copyright, and that is in the copyright in the TRIPS agreement in much of the legislation. And these legislations ask that the remedies are time effective, swift. So, and you have the right to enforce the right not to wait for damages, because damage could not be a sufficient incentive to comply. So compliance is the target, and compliance must be enforced per se. So this is in the intertwine between procedural and substantial law, and it's still something that it's discussed anytime. I have another case on the same tier. So what's the current status? The case is won, and it's permanent, but of course it can be appealed, and actually has been appealed. And but even if the appeal is rejected, the order will stay until the full merit is discussed and won by either party. So it's something that if we are successful, as I expect, frankly, we are going to be to wait more time for any a second decision on the case in the full merit in a few years. I expect this. I cannot comment much more because, as I said, it's still under appeal. So we have a case to defend, and I don't want to compromise my defenses. But this is pretty much the. I think I believe in honesty. A genuine report, even from one of the parties, of what has been going on. So I thank you for your attention, and of course, I'm fully available for any questions. Thank you.
Thank you, Carlo. That was an excellent presentation. Now, while people are getting their heads together and considering what questions they have, I just wanted to touch on the fact that Italy has a civil law structure, the same as we saw in Germany. So now we have two jurisdictions with civil law very clearly showing that open source licenses are enforceable. I was wondering if you're aware of any developments under common law which indicate the same type of certainty.
Well, we know from actually the first case I know of is Jacobsen Katzer in the States. Interestingly, that was I think artistic license. I can't remember the cost, but it was a permissive license, and that was enforceable. And then we had a number of cases brought in the States by Software Freedom Law Center first, then more recently by Software Freedom Conservancy. And of course, there is California case, I can't remember the name, sorry, claiming, and that's quite interesting. I'm very interested in the outcome, claiming that in some cases, even the not the copyright holder, but the client, so someone who's been offered compliance and by the license itself has not found satisfaction on that, and so they are claiming. But yeah, and for other jurisdiction under common law like UK, England and Wales or Ireland, I'm not aware of many other developments.
Thank you, Carlo. I was asking because in Asia, quite frankly, most of the countries are closer to civil law. So the focus is on what happened in Germany, what happened in Italy. But I'm sure our long tail audience will also have the Americans in once they wake up.
But I know that in China, we heard news of a also a GPL case stating that GPL is an enforceable contract or license. That's something relatively recent. I think 3-4 months ago. That has been discussed as well.
Yes, I do hope we'll have a presentation on that soon.
Okay.
I think there's a question in the chat for you as well, from Steve.
I was trying to adjust my glasses. Unfortunately, the age is demanding a toll on me. You said a result means that the defendants lost the right to GPL. I assume you mean lost the right to use the particular work that is licensed under the GPL, not that they lost the right to any other GPL license work. Yes, I confirm that's I was too short, and yes, you lose the right under the GPL to use that particular artifact or artifacts for which you have violated the copyright. Of course, if a copyright holder distributes software base A and software base B, and you violate software base A, I think it's quite clear that your license under the same license GPL for artifact B, that license still remains unless you do the same thing and you are terminated as well on that. And yeah, and if as long as the source code is in common, that's quite interesting. I've never thought of it, but that's quite interesting. I can submit that for the set of the software which is in common between A and B, you will be terminated as well, because the termination is on a piece of software and an artifact, I would say. So, but that can be as complicated as you want, and I'm sure that by continuing these cases and with more success having been achieved by free and open source software, these cases will multiply or increase in number at least, and more fantasy case would. Now, not fantasy cases that only your fantasy can think of now will become reality in the future. Thank you, Steve. And it was Steve Kilbane asking.
That was a great question.
Yeah. So thank you for being able to correct the statement, which was I realized. Well, I'm not reading, so I'm just putting it off the cuff. So sometimes is not 100% accurate.
Hey,
oh, go ahead. Sorry.
Sorry, I have a question. This is Prasad calling from California. So thanks a lot for that description of the case. And first of all, congratulations on winning that. I think it was very clear as to how the GPLv3 got enforced. So I have a question around, from an organization that, let's say, uses a lot of inbound open source dependencies. Do you perceive that this latest ruling, will, help make those organizations make a better decision, or maybe have a stronger guidelines per se in their usage of third-party dependencies, which associated licenses, that is GPLv3 in the future? Or how do you think that the broader organizations in the industry will react to this ruling? I mean, do you foresee that? I mean, I'll give you an example. Like, for example, in some of the organizations now, they outright tell their teams not to use any third-party dependencies that are associated with an extremely restrictive license, something like SSPL or NPSL. So do you see a possibility of GPLv3 getting put in that category, or do you still see that GPLv3 is still getting the usage and the dependencies still being used?
No, I understand your question, and actually this is an ongoing discussion with many. So it's commonplace to have quote forbidden unquote licenses. And I'm having this discussion with, for instance, because this is public, with the Eclipse Foundation. Actually, if you go to the Eclipse Foundation policy, IP policy, you find I don't think it's not forbidden, but it's deprecated licenses, and the GPL family is within that. So it's true that copyleft licenses have more demands, more conditions, so they could be more problematic. That there's no denial to that. But at the same time, on the one hand, initiatives as OpenChain are beneficial, because whatever and however complicated the complying with licenses, having a structure, having procedures, people knowledgeable, and everything helps. And it's like paying a price. Some software is worth paying a higher price in the proprietary place, and some software is worth having a higher bar on compliance, but it's still valuable. So of course, there is also the problem of incompatibility. So when you, however you try to be precise, the combination is impossible on licensing terms. And this, of course, is an intended consequence of copyleft licenses. So I would say that each case, any case, are a case apart. So there is no general statement on whether a license should be avoided or not avoided. It's always a balance of costs and benefits. If the software is good and there's no alternative, I don't see why you don't have to, you have to exclude using it just because it's a GPL. And it's unfortunate that some take a 100% clean-cut approach, avoid that. That's, to me, is nonsense. On the other hand, it's beneficial to have clarity on what you are permitted and what you are not permitted, what you're required and what you are not required, what the consequences are. Because somebody could be tempted to take a chance, and having enforcement is like a tantamount to saying you are not taking chances, because maybe you're lucky, but the copyright holder doesn't take any initiative because it's complicated, because it's costly, it's not worth, and they might even not care. But on the other hand, you have the odds are that you can face consequences, and you are forced to redo the thing over and over. And of course, in the OpenChain, we don't really base our assessment on risks, but we base our assessment on compliance and non-compliance. So despite the risk of being caught, we avoid infringing, because we are, as I said in another presentation, we try to be good citizens and to lower the friction and try not to poison the well that we are drinking water from.
Great. Yeah, no, I completely agree. I think that's a very balanced approach. On one hand, you do have to take into consideration the functionality of that dependency, and at the same time, try to weigh in against the merits of potential compliance risk, if you indeed take that and make it as part of your paid service. And yeah, I agree. Yeah, thanks for that clarification. Appreciate it. So it's basically what you're saying, it depends on case-by-case basis. So this ruling may not have necessarily a very strong result in one way or other, where folks trying to avoid altogether those OS components with GPLv3 associated with them.
So I would be. So this is because of the recent developments that you actually was discussing the OpenChain. in the OpenChain newsletter, sorry, the mailing list early this morning. I would have been more concerned, and what I would be more concerned of the McCarthy, so to name it, approach of a gacha approach instead of the proper way of free and open source software. So to if there is something going wrong, approaching the alleged infringer and try to find an amicable solution to in order to have compliance rather than damages. So
right.
That's this is quite important. Yeah.
Great. Thank you.
So we have another question. Do you know if the core documents will be made public? No, the documents are not being made public. In theory, unless the court orders the decision to be made public, the interim cases are not public per se. In this case, the judge ordered the publication of the decision on the website of the defendants and on the Facebook page of the defendants. And so we are able to discuss more the particulars because the full decision has been made public by this order and by compliance to this order by the defendants. But otherwise, no, and by definitely not the documents. The documents are outside. Of course, the source code is public, but that's it. So I think we are well past the time. I'm available to take maybe one other question, but I don't want to abuse more of your patience and time demands and time. So
I have one question to end, which is related to what do you think the influence of this case is likely to be in judgments in other civil law countries? Do you think it would be directly applicable in influencing them or less so?
Usually I would say not much, but because copyright is it's a global system of law worldwide, more so in Europe, because we have a software directive and all the national legislation is influenced by this direction. National, I mean, state level is influenced by this, and we have a Supreme Court in Europe that could decide on actual implementation and interpretation of the law. A case in the European Union could have direct influence to other cases, and so I think the German cases have could have an impact on Italian cases, and so on and so forth. And in general, the reasoning of the judges could be influential. Of course, we are not a common law system, so it's not like in the States or in the UK, whether they can influence each other as a judges creating law. But on the other hand, this case could be convincing, could be shaping the law as applied by the courts in other places as well. Yeah, especially when the jurisdiction and the legislation is so close together, so intimately connected.
Thank you, Carlo. And on that note, we'll wrap it up here. So Carlo and his colleague Alberto at Array Law have obviously done a great job. You'll find them in the OpenChain partner ecosystem. And of course, they both have an incredibly long history in this field. They know everything that you might need to know. So I recommend keeping in close contact. All right, everyone, I will see you at the next webinar in 2 weeks. Thanks again, Carlo, and have a lovely, lovely day.
Thank you, everybody. Cheers. Have a nice day.
Thank you.
Bye. Bye-bye.